Seven-judge Constitution bench of the Supreme Court has ruled 4-3 to overturn a key 1967 judgment on the Aligarh Muslim University, which removed the minority status but left it to a regular but yet unconstituted three-judge bench to decide if the institution should be granted this again. The bench, led by outgoing Chief Justice DY Chandrachud, who authored the majority judgment on his last working day, struck down an earlier ruling that said that an institution incorporated by a statute could not claim minority status, but left the question as it pertains to Aligarh Muslim University to a regular bench.
A big relief for the Aligarh Muslim University in the long-winding minority status case in the Supreme Court. In a 4-3 majority judgment, a seven-judge constitution bench headed by Chief Justice DY Chandrachud on Friday overturned the top court's 1967 ruling that described AMU as a central university and denied the minority institution tag. The court referred the issue of the minority institution tag to a new three-judge bench.
We honor the judgment, that's all. We will wait and we will discuss with our expert for the next course of action. With our legal experts, we will discuss and we'll wait for the next course of action, and we will have discussion with our legal experts. We have a team of legal experts.
The court also laid down the parameters for any institution to be called a minority institution. The Chief Justice emphasized the importance of identifying the university's actual point of origin to establish its minority status. Because AMU has been incorporated by imperial legislation does not mean it was not established by members of a minority community, the court said. It was founded in 1875 as the Mohammedan Anglo-Oriental College and converted to a university by the British Raj in 1920.
So the tests include what is the history, who put the money in, who are the people involved, which community it was meant to primarily help. All those aspects are part of the test, which at least in my personal view and assessment, AMU should hopefully be able to meet. But that is a test which will be applied to the facts of AMU whenever that smaller bench sits and then makes that determination.
The much-awaited ruling has also been welcomed by the student community at the Aligarh Muslim University.
एमयू की सोच की लड़ाई है और एमयू की जो सोच है, एक लंबी सोच, आज उसकी जीत है। ये आज का दिन हमारे ऐतिहासिक पल है ये, और इस दिन का बहुत दिनों से हम लोगों को सभी को इंतजार था।
The fight for minority status has gone on for decades. The 1967 order of the Supreme Court denied AMU its minority character, saying it is a central university. A parliamentary amendment in 1981 restored the university's minority tag. But then Allahabad High Court in 2006 struck down the 1981 amendment, again denying AMU minority status. Appeals were filed against the Allahabad High Court order by the then central government as well as the university. Further muddying the waters, the NDA government in 2016 withdrew the government's appeal, citing the 1967 judgment.
The Supreme Court has finally given some finality to the Aligarh Muslim University, giving a criteria and a real framework for a regular three-judge bench to decide whether it should be given the minority status or not. Either way, this has far-reaching implications for all religious and linguistic minority institutions across the country. In New Delhi, Sunil Prabhu, NDTV.
Well, joining us now, Shraddhan Farasat, senior advocate in the Supreme Court, somebody who's been closely involved in this case, and Ashwini Dubey, an advocate of the Supreme Court. Thank you both very much for being with us. Shraddhan, let me come to you first, just from a legal standpoint, so that we can understand this a little better. How does today's Supreme Court ruling impact the interpretation of Article 30 of the Constitution regarding the establishment and administration of minority educational institutions?
Yes, I mean, that's a great question, Vishnu. So the question before the court in that 1967 Aziz Basha case was that because AMU as a university, not as a MAO college, as a college it existed from 1870s, but as a university was established through an act of 1920 of the then imperial legislature at Delhi, correct? Now, in that Aziz Basha decision of 1967, the court said, and that was 5 judges, that because it was a legal enactment of an imperial legislature which brought it into existence, therefore AMU is brought into existence or established for the purpose of Article 30 by the imperial legislature and not by a minority community. That view today has been reversed by making a distinction between legal incorporation of an institution, which of course can be through a legislative act of a legislature, and establishment of an institution. So what the court has said, that it is very well possible that a minority community can establish a university or an institution, but using the legal methodology or incorporation of any kind, including that of an enactment of a legislature. So that decision which held that for that reason AMU was not a minority institution has been overruled today.
Right.
And it has also set 4 or 5 important principles which are to be the guiding principles for determining if an institution has been established by a minority community. My prima facie assessment of those principles is that AMU should be able to satisfy all those requirements.
Right.
And in fact, they are pretty much in line with the way AMU was formed. So I think it is in terms of for the minority status for AMU, it brings a reasonable clarity, although not a conclusion, because that still has to be argued and brought by a smaller bench.
Right.
But it does, as far as those who are advocating for the minority status, it takes their case substantially forward.
Yeah. Ashwini Dubey, just to try and get your understanding on this, in terms of administrative autonomy, does the overruling of the 1967 verdict today suggest a shift towards allowing more administrative autonomy for institutions which have been established by minorities but regulated by central legislation? I'm trying to look at how the verdict today impacts other institutions.
That's a question which is to be decided by the 3-judge bench, which has been left over by the majority judgment today by the Honorable Chief Justice of India and the bench led by him. The view in Aziz Basha that minority character stops when a statute comes in the force, that is only overruled. But the questions, the test, that which is to be examined, that the requirements which is for claiming protection under Article 30, and the relevant question which is to be decided by the 3-judge bench, whether the expressions establishment and administration should be read conjunctly or disconjunctly. This is the question. And now if you see the Justice Surikant's judgment, that says that does define the term established, because they have extensively distinguished the Aziz Basha judgment also. So the pertinent question is, what is the scope and meaning of this term? Can a university be established without statutory intervention? If not, whether the recognition of a university by a statute amounts to establishment by the legislation? And see, is there any conflict in the opinions of the court as the Aziz Basha? In Aziz Basha's case, if you see, that has decided that AMU is not a minority institution. So for the time being, it has been declared that AMU is a minority institution, but what are the tests? What would be the criteria to administer it? What would be the criteria for appointment? What would be the criteria for appointment of the faculty? Yes. What would be criteria for implementing the reservation which is given under the Constitution? Who would be the teachers? How are they governed by the other legislations of this country? Because if you see, the regulation impact is necessary.
Yes.
So the regulation impact has to be looked into by 3 judges bench.
Shraddhan, considering Aligarh Muslim University was established before independence, much before independence, how does today's judgment reconcile the historical intent of the founders with its current legal status, especially in the context of national importance, right, versus the rights of minorities?
Yes, so that's a very good question. So I think the court, the majority of 4 judges, speaking through the Chief Justice, answers that very directly and says that whether or not you are a minority institution is not going to be determined by whether you were established pre-1950 or post-1950. So you could have been established in 1875, but if you meet the test of what is a minority institution, then you will be considered as a minority institution beginning 1950, because the concept of Article 30, of course, Article 30 did not exist pre-1950, right? I mean, the concept of minority in a constitutional sense was introduced along with the Constitution in 1950. And one of the arguments was that because it was done in a colonial era, and therefore, you know, any institution from that time cannot be minority, which in my respectful view is, something which obviously cannot be agreed, because that means all institutions which were established pre-1950 can never be minority institutions. And that was squarely and directly rejected by the majority. So that issue is sort of now, pretty much conclusively decided. What was your second question you had asked connectedly, Vishnu?
No, I was asking about how today's judgment, or how does today's judgment reconcile the historical intent of the founders with the current legal status, especially in the context of national importance, which is a larger India-wide cause, versus the rights of minorities?
Correct. So I think it deals with that again very directly, and in my view correctly, that it says that the intent of who the formers were, you have to look at the entire circumstance of formation. You can't look at it very technically in the terms of at immediate, whether it was just the act which established it. You have to look at the intent. You have to look at the history. You have to look at the communication between those who were, the people who were the founders. And you have to look at who donated the money, who donated the corpus. All of those factors, when you look at it together, you will get a clear intent whether it was to be established for a purpose of benefiting a minority or not. And in my view, I think on all those fronts, AMU has a reasonably, all the tests or indicias which have been indicated by the court today, AMU has a reasonably and a very, very arguable case to say that it meets, in fact, that test fully. And on the national importance aspects, one of the arguments was that AMU and BHU, both are universities which have been in the legislative list in Schedule 7, been identified as institutions of national importance. So one of the arguments raised by the central government and other proponents who were saying that it's not minority, it can't be a minority institution, was that if it's an institution of national importance, it can't be a minority institution. And that argument in effect has also been rejected, because it can't be that only majorities can establish institutions of national importance. In fact, minorities are equally well entitled. They are as much a part of the nation. They can establish institutions of national importance. So I think on all fronts, the judgment is really a vindication of the position which the university had taken and those who were supporting the position of the university. And I think on all, in fact, most of the arguments, as far as I can recollect, have been accepted by the majority of the court.
Ashwini, one final question to you. Keep it short. I understand it's not always possible, but I'm running out of time. Could this judgment lead to similar legal challenges by other institutions claiming minority status? And what criteria could now be used to assess these claims?
See, of course, this would be having a far-reaching impact throughout the country, Vishnuji. But the moot question is whether the Muslim community in the AMU case presumed to be a minority at the time AMU was established. Because it was established in 1920. Was there a Muslims were given minority status? This is the question is to be decided by 3 judges bench. And that would be having...
No, that is incorrect. That is incorrect. I'm sorry. That's not at all the question to be decided by the 3 judges. That has all been rejected by this bench itself. That was argued before this bench. It's been rejected. 3 judges now has to see if the 4 indicia which has been set by the 7 judges here are being met by the establishment of AMU. What my learned friend is saying is not at all the question before 3 judges. I'm sorry, I have to correct him on that.
Para 112 of Justice Surikant's judgment categorically
says...
That's
a dissent, sir. That is a dissent. That is a dissent. Majorities and dissent.
Locus of not hold up. And now it is not going to be, and today, Vishnu, it would be deciding how it will be run, what is the criteria to be let down, how it will be administered. That Article 30's impact, that has to be decided by 3 judges bench. And that's the battle is still not over. Let's see what happens tomorrow. But that would be followed in throughout the country as answer to your question, Vishnuji.
All right. Look, fascinating discussion. I wish I'd spent more time on this. Thank you both very much for joining us.